Welcome to the American Reformer Podcast, hosted by Josh Abatoy and Timon Cline. Our mission is to promote a vigorous Christian approach to the cultural challenges of our day, rooted in the rich tradition of Protestant social and political thought.
All right, welcome back, everyone, to the American Reformer Podcast. Usual host here, Timon Cline, editor-in-chief, and joined by other editors today, Ben Crenshaw and Mike Sabo. Guys, thanks for coming to the studio today. And I guess our format's a little bit different today, Ben, so I'll kick it over to you to get us going here.
Yes, thank you, Timon and Mike. Today, actually, we are kind of interviewing Timon because he is one of the principal co-authors on this law journal article that he co-authored with Josh Hammer and Yoram Hazony called Everson Must Fall, published just late this spring in the Harvard Journal of Law and Public Policy. So it's a very interesting article. So Timon, you probably don't need much introduction, but maybe just tell the audience how you came to write this article with Josh and Yoram, and just a little bit about the argument in it.
Yeah. I hope I don't need too much introduction for the regular listeners, at least. But we started, as we were talking about before we started recording, I mean, that some iteration of this essay has been going back and forth between Josh, Yoram, and myself for years. Yoram came to me, I think, 3 years ago, and said, we need. He wanted to make some kind of argument like this in public in some way, and he wanted me and Josh Hammer to do it with him. Both of us are lawyers. That was part of it, but also shared interest in the particular kinds of arguments we make here and the particular outcomes we are shooting for. And back in 2022 in the summer, you had, as we opened with the piece, you had the Dobbs decision, right, overturning Roe, which was, of course, watershed moment for whatever you want to say, like conservative legal movement stuff, right? People have been working on this for a long time, rightly so. And I know for a lot of people, especially some of the amicus briefs written by some of our friends, like over at James Wilson Institute, we're arguing for a more sweeping strike down of Roe on sort of 14th Amendment basis and all this. But the Dobbs decision in particular kind of, spurred us on to frame things the way we do, where Dobbs stands for like more than the overturning of Roe. It stands potentially, as we see it, for some kind of return to functional constitutional federalism of the original model. Our argument being, and I think even people that wanted a more sweeping ban would agree that originally, Roe never should have been a federal question. It's a moral question that should have been decided by the states anyway. So this is kind of a return to status quo from Justice Alito. So that was partly inspiration and partly what we see as like an opening to start making this argument of what the next long-term project should be for conservative legal activists, lawyers, judges. What should energy be put behind Roe in so many ways? He destroyed our body politic, had introduced certain sin at scale and that plagues society even still, and take a long time at the state level to battle against abortion on demand more. But so the question was, what's the next thing that has sort of pushed us further away from what we had in the late 18th and early 19th century, right? What's the original constitutional order, not just legally and institutionally or structurally, but culturally, morally? What's the other thing that's plaguing us? So we said, what we say is it's Everson versus Board of Education. So this should be the next project, long-term project, 50 years, whatever, it takes. But this is really the first kind of volley to get people thinking about it. It's the job of lawyers to get creative in how they do this, to look for opportunities to sort of forum shop, all these things, plaintiff shop. But we're just trying to get it on the map so that people could start and demonstrate, why this is the case, that Everson is such a big deal.
Excellent. So yes, your article centers around this 1947 Supreme Court case, Everson versus Board of Education. Tell us a little bit, like, what was that case about? What did Justice Black, rule on? Kind of what was the lead up to it? Your basic argument is that this kind of the striking down of public religion and what you've called elsewhere kind of the institutionalization of public atheism is really a project of the courts. So give us an overview of what Everson was about and kind of what led up to it. What was the decision, and then what were some of the cases afterwards? What's been the ramifications?
Yeah, and I think, and you guys want to talk about this with me as well. I'm sure we can describe it of what did we have before Everson? So this is like the breaking point, but it's the most important point for people to kind of understand, why it's problems. We can talk more later about, what was life like at the founding or up even into the 20th century. But once you get to the mid 20th century or thereabouts, you start having pressure in various ways against, we'd say, publicly supported religion generally. We're long past any sort of particularization of that support in any real sense. It's already quite, there's no established state in 1947. There's no clergy being paid. All we're sort of going to be talking about in Everson and what follows are like general public benefits, and especially education, right? Most of the battleground is in schools. And I think that's for obvious reasons. And the left always kind of gets this. But Everson, is such an interesting case because it's in New Jersey. It's having to deal with a sort of public voucher system or public accommodation for transportation for school children, right? Again, almost all of these have to do something to do with schooling. And so it was allowed for, in this case, I think the majority of people doing this were Catholic. A lot of Catholics. There's also a lot of Jews in New Jersey, but I think in this case it was mostly Catholics that were taking advantage of this public benefit to get their children to their private, sectarian schools, which was technically allowed, right? So the case is brought up that this is a violation of the First Amendment, right? You're not allowed to do this. It's public money helping religious people do religious things. What's interesting in the case, and this is often the case in Supreme Court precedent, depending on the issue you're looking at, is that the appellant loses in Everson, right? The New Jersey, the court decides in New Jersey, this is totally neutral. There's no favoritism. Everyone's benefiting from it. Why not Catholics or Jews or Protestants as well? This is totally fine. So they lose. You would think the case in controversy has been solved, actually, at that point. So it's the dicta that we're dealing with that creates all this. So in his dicta, Justice Black, what he's doing and what the court has been known to do is sort of set themselves up for the case they would really like to see, so they can get done what they want to get done. So you're kind of telling other people how you're thinking about the issue, even though it doesn't really apply to the case. That way, lawyers will bring you good cases and better cases. So Justice Black, kind of goes through, decides, even though the case in controversy doesn't call for it, that they're going to go ahead and since Cantwell had already incorporated the free exercise clause before, now they're going to follow suit and go ahead and incorporate the second clause, or as all grammarians will tell you, there's one clause, but they've decided to incorporate the second half of it. So they do incorporate the establishment clause, again, for no particular reason, even other than they wanted to, and proceed to sort of describe why they're doing that, right? And it's just if you've at this point of our article sort of reviewed the history of pre-Everson life and jurisprudence, you'll notice how aberrant, Justice Black's sort of story he's telling is. But they decide to go ahead and do that. And these subsequent year, they kind of get their wish in McCollum of what they're looking for, and they can sort of fully execute now that they've already incorporated the Establishment Clause. So a state now can violate the Establishment Clause, whereas previously only the federal government could. We can talk too about the interpretation, original intent, the Establishment Clause, according to which this makes no sense. But Black has all sorts of comments, both in Everson and McCollum, which deals with schools in Illinois. That you're not allowed to support religion, no religion, or anything in between. It has to be completely neutral, is what the state has to be. Federal government, state governments, complete neutrality. And this can apparently this neutrality can be violated very easily with sort of quaint things such as in McCollum, where they're having optional, parent-approved theology classes that are extracurricular, elective, for students in public high schools. So the parents want it. The students don't have to do it, but it is, a public school sort of option for everybody. There's Catholic ones, there's Jewish ones, there's Protestant ones. That is a clear, they say in McCollum, violation of the Establishment Clause, now that we've incorporated it last year, right? So this is how you get sort of off to the races, and the court makes very clear, what direction this is all going to go, by starting with things that are as petty as, busing and extracurricular Bible classes.
Could you talk a little bit about the, I guess, quote, historical research that Justice Black did? I guess he did rely supposedly on some, law historian, but he really went back to, Jefferson's letter to the Danbury Baptists, 1802. Jefferson was president. This famous, wall of separation, which I think the court first talked about. I think it was Justice Waite in the Reynolds case, 1879. Yeah, that's right. Could you talk about what, first, there's a lot of layers to this. It was, okay, this was a private letter that was actually never actually published. So kind of almost like akin to like City on a Shining Hill, which like nobody really ever read until probably Ronald Reagan in the 1980s. Like no one ever really referred to that. Kind of, how we should kind of view Jefferson. What was he doing? And then, really who's to blame for this? I mean, is it Jefferson for, introducing, I guess, some form of, liberal kind of neutrality? Or is it really, I think as you've suggested, Black and other Supreme Court justices who really kind of just use this really as a means to kind of foist, their own predilections kind of upon the American people? Yeah,
of course, this is where probably most memorably for everybody is where you've resurrected Jefferson's Wall. As you said, that was initially sort of put into the American bloodstream in 1879, I think, is the Reynolds case, Reynolds versus United States. And it was Justice Waite. In that case, another interesting case of dicta, because that case is about whether violating the Bigamy Act by Utah, right, and the question of their statehood. And that case, the thrust of it basically is Justice Waite saying, absolutely, the government has a right to decide what you're doing in your bedroom, and we're not going to allow bigamy. Also, here's this thing about Jefferson I found that's super interesting. That's how the case goes. It's like completely, he's wanting to make the argument this is not a violation. He says it's not a violation of their First Amendment rights. But he pulls in just for fun. And there's a great article actually years back at First Things that talks about how it is Justice Waite came across this letter from Jefferson. He was sort of strolling around in D.C. and ran into his friend, whatever the guy's name was, who founded I believe the founder of the Naval Academy, who happened to be a Jefferson historian. And the guy was sort of like, here, use this. And that's how you get it there. We have like grand ideas about how the Supreme Court justices come to their conclusions, but that bubble can be burst easily by the history. But as we talk about some in the article, what is this use of Jefferson, which now, I mean, it's a great demonstration of how the courts really dictate in many ways public opinion and public sort of sentiment far beyond the particular rulings they issue, right? I mean, the wall of separation, the idea that separation of church and state in that way is in the Constitution, all these things, very, very common popular opinion. And you're sort of like, where's this come from? Well, no one's talking about it until the courts start talking about it and sort of trickles down. So culture is downstream of law, I would just say. But Jefferson, we do talk about, to some extent, in our article, I wrote another one at American Reformer a little while ago about the same issue. I actually don't blame Jefferson too much for all of this. Whatever his private opinions, which were certainly radical. I mean, he had a low opinion of organized religion, of course. Thought maybe it's necessary for like weaker men to help develop virtue. Was pretty intolerant of denominational squabbles, all these things. Thought they were counterproductive. We're all aware of kind of his sentiments. But his public arguments, I actually think he's a strict enough constitutionalist, maybe too strict in some cases, that he maintains, if you read Jefferson fairly, so if you read his letter to Danbury Baptists and then read it in conjunction with his second inaugural address, it's very clear that he wants to maintain the status quo, which is states can basically do whatever they want with religion, and the federal government cannot touch it. Right? He says this in his second inaugural about his first term. He says, we follow the Constitution. That's why we didn't touch religion, because we're the federal government, and we're not going to bother the state establishments. The reason he wouldn't call for a fast day as president was for this reason, whereas he had called for one as governor of Virginia when urged to. He thought that this was proper. So and if you read the letter to the Danbury Baptist, the actual text, which has been given far too much authority in our lives, but if you do read it, his argument there is entirely consistent with this. He's just saying, here's what the national government can do and cannot do. Your state government's basically good luck. Maybe we hope they change, but there's nothing, we can do about it. So I don't blame Jefferson for this. Actually, I think he had a proper interpretation, and that's what he explained when he says, in other contexts about the Declaration, that he's just trying to express the American mind. Actually take him at his word. I think he's being honest. I don't think he's sneaking in things for his own. And partly, I'm convinced of that because of this fact with his constitutional interpretation. I think he's trying to be honest and fair, and certainly still saw some necessity of public religion. The anecdote of him carrying around the Book of Common Prayer in D.C. on a Sunday, and someone stops him and says, "Why are you doing that? I know you don't believe anything in it." He said, "No government's ever survived without religion." So he at least thought you should, he's at least Machiavellian enough, to appear to have the pieties. In any case, so that's how we get the wall of, the wall of separation is in Reynolds, which I think is only the second time that the court had ever considered taken a case, granted cert on a First Amendment case. I believe the other one was maybe 50 years prior, which basically affirmed standard doctrine. We can't do anything about this. It's a state issue. But by the time you get to Justice Black, clearly a lot of sort of sophistry has occurred, right? Because Justice Black uses Jefferson entirely differently than Jefferson used himself or anyone had prior thereto. So now you have this in Black, you see things that are very familiar to us now that are arguments made constantly, which is strict, impregnable wall. It can't be scaled. It can't be penetrated. In fact, it's probably our job to go around and touch up on the mortar every now and then, add a few bricks, make the wall, the wall just got 10 feet higher, whatever, which seems to be the general posture of the court since the mid 20th century. I don't know if that got to all your question, Mike. Throw something else back out there.
No, that really did. And I think that's actually, especially the piece that you published in American Reformer recently, I think especially for the new right, that's very important because we're always looking at the villain, the point in history where it all went bad. And so I think a better approach is like what you said. Okay, we may definitely disagree with Jefferson's views on religion, the importance of Christianity to maintaining a polity, etc. But at the same time, let's focus our fire on the actual people who took and ran with this, which is mid 20th century liberals, essentially, and then just absolutely, put pedal to the metal after that. So I think focusing on the mid 20th century, I think is a great place to start. And then obviously after that, it's really important. I think when you look at, Jefferson and Madison, obviously too, gets brought into this as well. You look at, I think, both their views on the First Amendment. I think they were, pretty out of step with Washington, with a bunch of the founders and the framers, certainly. But at the end of the day, those guys compared to now, we should mind them. They're on our side. They wouldn't have even considered, trans insanity. I mean, just all the things, abortion on demand, that's just so commonplace today. So I love that. Just using and mining the people where we can and saying, look, the bulk of history up until 50 years ago is completely on our side. Let's use it. So I think that's so important, and I think a very important lesson just for the new right.
Yeah, I couldn't agree more. I mean, one thing we point out as sort of an aside is like where, Justice Black tells this story. People can read some of the quotes we have, but they really should go read this opinion, his majority opinion on this. Just as it's an important moment in American history generally. But the story he tells, is sort of the same story you hear about the wars of religion, and I have all kinds of thoughts on how we should frame that. But it's this juvenile version, right? And it's terrible. And it's so America has almost, and the contrast we point out is just like if you read FDR's State of the Union address from 1939, and then you go read Justice Black's opinion in 1947, they are two totally different perspectives. You can hate FDR. We're just saying the way FDR frames the story of the country and the character of the country is entirely different in 1939 than it becomes in 1947. Meaning it really is something post-war that we're usually wrestling with. It's not even the progressives did the tons of damage, but on this particular issue, it's not quite the problem. And really, this stuff is as you start going through these cases, it's like gasoline gets thrown on the fire it's really the 1960s, so it starts kind of in the 40s and through the 50s, but it's the 60s, which is the same place that you develop lots of other stories and narratives that kind of control public opinion and policy at this point, too. So you don't have to go back that far. I mean, this is why I think who's it at Hillsdale that wrote the book on recently, Mike. I'm blanking on his name. All I can think of is Paul Ray, but it's not Paul Ray. It's
Kevin Slack.
Kevin Slack. That's why Kevin Slack's book is so important, because his treatment of this period of history is, and I don't think we can overstate the radical changes that happened in the mid 20th century onward. And it's the source of most of our ills. If you could roll that back, you'd have a lot of stuff that you really want. You don't have to go that far back, like living memory, like people that were born, before all this happened. So that's part of the point, is like not just the difference between this and the founding. That's obviously a stark contrast, but even a decade before this is something really happens, in the mid 20th century on like all fronts, and even in the courts and in their conception of America. And of course, they're not just making this up. It's the type of histories they read. Judges are reliant on these things, and and the clear agenda. I mean, this is this line. This is a famous line from Black. There's no way to, in light of any kind of, even if you hate it, history of the ratification debates, maybe they didn't have good data on that at the time, or just the plain meaning of the First Amendment when he says, the Establishment Clause has to mean at least this. It means that neither state nor federal government can set up a church. This just doesn't jive with anything that you could possibly read at the time, including Jefferson. It can't possibly mean, the First Amendment can't mean this if it requires the 14th Amendment to make it happen, right? This doesn't make any sense that it means in some way. This is about like Justice Gorsuch saying that statutes from the 1960s include trans people. It's just like, it can't mean that. Wait, it wasn't invented yet, right? Like we don't have it. So it can't mean that. That's what I mean. It's just, it's unbelievable. It's sort of the hubris in doing this. So this is why we want to expose people to these, this sort of string of cases, because it's fascinating.
Yeah,
and and everyone should read. Believe it's Judge Stewart in New York, but the point being, the appellate case before it goes up to the Supreme Court in Everson. I'll find his actual name, but his opinion in the lower court is fantastic. He has all of it exactly right. And he makes this excellent historical point where he's like, actually against just using Jefferson and Madison. He was like, it makes no sense we're using all these private letters and these things. Like, this doesn't explain anything. What you need to use is essentially public consensus documents that will tell you where you need to go. So that's why you should rely on state constitution, so on and so forth. We've stated that in the introduction, that his method is essentially ours, that we've adopted to demonstrate the case. But in any case,
yes, I was going to say that it is remarkable from a layman's perspective. You look at the Supreme Court. This is an august and revered body, supposedly these great, wise, men, discerners of law and history and politics. Then you can read their opinions and you think, are you kidding me? You just randomly pluck a private letter from Jefferson, make it a crystal ball. Roger Williams rises from the dead when he wasn't known at all. And suddenly, he is the archetype of church-state relations in America. Then you have just pages of dicta that these judges go off on. And then that becomes the precedent going forward. So the whole thing, you guys do a great job of just pointing out the mess. I thought one of the excellent points you made is the very idea of incorporating the Establishment Clause defeats the very purpose of the Establishment Clause, which is like an anti-state incorporation statement. It's literally undoing the very thing that the Establishment Clause is supposed to do.
Yeah.
But you do make the point that the Free Exercise Clause does in a way protect, the rights of the people to practice their religion. And so it could be, in a sense, it could be incorporated still, less incorporated through the 14th Amendment and more just it's actually protected by the states in their own constitution. So it makes sense for there to be an individual right to free exercise of religion, but there is no individual right to not have an establishment of religion in your state. That is wholly made up by the court itself. So here, a question I had, Timon, or at least I think a good part of your article was you guys talked about the Blaine Amendments in the late 19th century. And that's scholars often look at the Blaine Amendments and say, oh, this is a precursor to separation of church-state doctrine and the Supreme Court. But you guys tell a different story. What's the different story about the Blaine Amendments and maybe what they can implicitly tell us about the 14th Amendment and the meaning of that?
Yeah, well, and if you'll allow me 2 comments on what you said already. I mean, there's I've had like the shell of an article going for a long time, looking at the way the court, anytime the court tries to do church history, and it's more frequent than you think it is, or realize it is. Courts across the board, throughout our history, do church history. By this time, you have essentially the equivalent in a way of like the trail of blood theory of history, or like landmarkism or something. It's like they've adopted this kind of, this comes from somewhere, right? Like, how does this get into the core, this general view of religious history? And it is like that. It's like string together the martyrs, and who the good guys are because the church killed them or whatever. And that's like where we should get our doctrine on these things. And so Roger Williams pops back up because he's persecuted. He's the outlier. He's the minority. He's the oppressed one. We've done the same thing with, I forget who it is, but several scholars pointed this out. I mean, Jefferson and Madison are just decidedly the minority report at the time of the founding, but they're the heroes, right? So there's something happens publicly, but also even within the courts where the narrative switch happens. Then your authority is relying upon whoever was sort of the outlier. And I just think it's fascinating. I also think there needs to be more work done on what free exercise as a phrase actually means at the time of the founding. I have not been able to find a lot of good stuff on that, and that's outside the scope of this article. But I think there's certainly, if you look at broad strokes stuff from like Barry Shane, most of the like, what's the referent, what's the subject of these clauses? And I think you'd have to say at the time of the founding, it's mainly communities and their self-determination. So free exercise becomes a little more complicated on what even the federal government could possibly do. I don't think it'd be incorporated either, actually. And because it is one clause and the way it's written, I often question what it means. Free exercise of what? Well, the thing that precedes free exercise is the establishment of religion. So is it the free exercise of just religion or free exercise of those establishments? It's an interesting question. And I'm sure there were varying competing opinions even at the time of the founding. Some people may have thought it really means we're protecting, individual people. I'm willing to tentatively bet that most people think of it as, it's the, protecting the free exercise of those religious authorities. But anyway, that's again outside the scope of our article. The Blaine amendments, right? I mean, come up anytime you talk about this stuff. It seems like you have to talk about the Blaine amendments. It's just out there. That's why we ultimately did, because like people are going to say, "Where's discussion of the Blaine amendments?" And the Blaine amendments, I think, are often framed the wrong way. I mean, what we know, there's the anti-Catholic animus, whatever. What they're, the language of these debates, and there is good work on this. This is like late 19th century. Is basically an effort to keep Catholics from taking over the Protestant culture. And so you establish your public schools as non-sectarian or quote unquote secular schools to keep, the Catholics out. The code it means Protestant, right? We don't want the Vulgate there because they're still doing all the stuff. They're just all of a sudden, called non-sectarian sort of schools. They're very worried. This is the same time period when you have, our integralist friends really enjoy this time period. This is when you get all the great encyclicals from the popes against Americanism. We know that there's even like a session in the Senate during the Blaine Amendment debates where the syllabus of errors is read in total from the floor, from Pius IX. So the fear of Catholics is very strong, and I think these sort of efforts, which ultimately fail. Some succeed at the state level. All of this sort of effort was kind of shooting yourself in the foot from the Protestant perspective, because you establish this language and this standard that is very subject to interpretation. It's obviously grown over time. But we think that the sort of discussion and debates over the Blaine amendments at the time indicate or support our thesis about the original interpretation of the Establishment Clause itself. There's no, the same people who have ratified and debated the 14th Amendment are debating this, right? And there's no indication at the time that there's any way to incorporate the Establishment Clause into the states. Otherwise, there would be a much more ready mechanism for them to accomplish what they're trying to accomplish through these sort of ill-formed Blaine amendments that never really, in the end, get anywhere. So that's our point there. I mean, it may at first blush sort of seem like the Blaine amendments defeat your purpose in our argument, but actually we think that the entire episode furthers our case.
Just going back to I guess, because you talk about this at the beginning of the piece and then at the end, and actually there's a great footnote that you talk about what establishment actually was, as opposed to kind of our view today, where it's, obviously some church that the state is supporting, that there are kind of different senses of what that word means. Could you just go into that and explain, what would a state like, say, North Carolina, Virginia, Vermont? I mean, what would a state establishment actually look like at the time of the founding?
Yeah, we do. I think we have sections, if I remember right, both sort of generally before the ratification of the Constitution and then after, right? And there's no change is kind of the point. This doesn't disrupt. 1789 does not disrupt anything. But you have, and we use Joseph Story on some of this as well, which is, of course, a great source. I always recommend to everyone basically anything Stephen Smith writes. And then, of course, Philip Hamburger's book on this stuff is excellent as well. And I think we cite them both frequently. But, you have, as you guys know, a sort of diversity of establishment types at the founding. Joseph Story goes through several different sort of options. Just in theory, you could have really sort of strict establishment, where it's one particular denomination that sort of, is ultimately favored in every way. You could have a more general or soft establishment where it's within one sort of religious umbrella. It's any participants in that, so it's multi-denominational. You could have particulars, sort of slid into that where it's like, well, all Protestants, but not so much or as much Catholics, which is basically what we had. and then you can, with that, another kind of version of that, which is the one Story himself in Supreme Court cases recognizes, and the court continues to, which is this just general Christianity that controls like the mores of society, right? It needs to be respected by the common law because it's the common and historic religion. So you have all these, establishments, not one thing. Is the illustration I often use is like in, 1L year of law school, they tell you in property law that property rights are a bundle of sticks. It's not like one thing, so the renter has less rights than the rentee, but he has some rights, right? His bundle is just smaller, has less sticks in it. But it's not like property rights is this one thing. It comes in various forms and you get more or less of it. It can ebb and flow over time, right? So establishment's similar. It's not like one thing, in my opinion. You just have pieces of establishment. And that's why you can't like pull it all in at once or root it all out at once. I mean, you see the slow trickle one way or the other. So at the, I'm sure we've discussed this in other contexts, and there's certainly been plenty of pieces in American Reformer on it. But at the time of the founding, you have each state with its own unique kind of settlement according to its people and its history, right? Like Maryland is very different than Massachusetts. Its history is very different. Massachusetts, has, of course, favoritism for Christianity generally, but the Protestant ministers are the ones that are going to get tax benefits, right? And they're pretty strict on this for a while. Various cases, state level cases, draw that out. That's the big, the Declaration of Rights. That's sort of the big move. Is they're going to Protestant teachers, public teachers are going to get tax benefits because we think that they should have them. New York does something similar. So, that's in South Carolina. They just declare themselves like generally Protestant at first. Georgia has rules about like who, whether clergy can serve in the legislature. So they're kind of keeping it. Those roles separate, but favoritism for Protestantism, obviously. Those like Southern states, typical for it to be like, you have to be a member in good standing of a Protestant church that we recognize in order to serve an office of any kind, right? Tests for office, very common. Very clearly Protestant in most cases, tests for office, right? Not just like affirmation of the Trinity, but you have to affirm like inerrancy of Scripture, both testaments. It's just in New Jersey. New Jersey is actually my favorite state constitution on this because it's so great to cite to like modern people, because you have an article, I think it's like 19, that's like it's exactly what you expect. It's like religious liberty, everyone tolerated, awesome, 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 and people are like great. And then it's like the very next chapter or article that says, but actually only Protestants will run this state, right? Just perfect. And like most modern people, they have no idea what to do with that. How could those two things be true at once? But it is what they did, right? It's a toleration. There is a tiered citizenship at the time. There's no other way to look at it, in my opinion. So everyone is tolerated. You're protected under the law in your goods, in your body, your person, your reputation. All these things can't be destroyed for the sake of your religion. And I think mainly what they're always getting at is any sort of vigilante justice against these people, persecution in this way. The magistrate has to, you see this in the Westminster Confession, magistrate has to protect his people. But that does not preclude favoritism or a sort of, standards for office that are very clearly geared towards one particular persuasion. In this case, generally Protestantism. In New Jersey, Witherspoon writes about this. He's like, there's Episcopalians and there's Presbyterians. Well, there's two types of Presbyterians. There's Dutch ones and English ones. And then there's Baptist. And because Baptists aren't very powerful, they always side with the Presbyterians. And then there's like all these other kind of people, but they don't really matter. So it's like Episcopalians and Presbyterians. That's it. These are like the political powers in New Jersey at the time. Those are the people that are going to serve in office, right? These are the people that have a vested interest in the country, in the state and in its founding. So these are the type. This is what we mean when we're talking about establishment. It's like favoritism for who's the leaders are, and then tax support for the clerical leaders. That's kind of it. They're both public offices in a way. And you're having a Protestant standard for who your leaders are. There's not much else that at the official level, other than more basic laws that would support generally Christian morality in public, and that's for the people, that's for everybody. Obscenity laws, blasphemy laws, Sabbath laws, all this. But really, the establishment clauses are like, we want to make sure we have Protestant leadership in this country. That's how I read them across the board. And then we're going to be really nice to everybody else.
Yeah, it's interesting because I think most Americans have been conditioned both by secularism in America and by the court's opinion that if you have freedom of religion or liberty of conscience religiously, then you can't have establishment. These two can't go together. And you guys do a great job of dispelling that kind of false dichotomy. You also look at New Hampshire's Constitution in 1784, Article 5 and 6. And I think Massachusetts, their Declaration of Rights in 1780, Articles 2 and 3 do this exact same thing where they say everybody has a right to worship. Oh, and also we have the right to support our ministers with tax funds. Mm-hmm. And in fact, I was just doing some research on the Anglican missionary arm in America in the early 18th century, the Society for the Propagation of the Gospel in Foreign Parts. And they, in the 1730s, they brought charges against the Massachusetts government for taxing Episcopal members in America to support the congregational ministers in Massachusetts. And they argued that you can't do this because the Church of England is the established imperial religion of the British Empire. So you can't tax the established religious members for the sake of dissenting churches. And the King's attorney, Philip York, and Solicitor General Thomas Talbot came back and said, no, actually, the states do have a right to regulate their own religion. And in fact, they can do this and you can uphold liberty of conscience at the same time. So none of you guys' rights are being hurt. So this was common in the early 18th century, all throughout the 17th century. This is actually a prevailing idea for 300 years in America, that you can hold free exercise and the right of religious conscience and the establishment of religion and government support of religion together without any problems. But I think, from my perspective, having read your article and studied these things, if a case like this, if the right case was brought before the Supreme Court, it would seem to me to be an easy, open closed decision. But I know the court has often been, in the program of social engineering. And I think that the prospect of a renewed religious federalism in which the states could potentially reestablish religion would cause a lot of anxiety, both for political elites and maybe your normal Americans. And so I wonder, you guys are very optimistic that a renewed federalism could work, but I'm wondering, what are some of the potential difficulties there, or perhaps dangers? I mean, obviously, America's religious landscape is totally different today than it was at the founding. And so we're not just dealing with varieties of Protestant denominations or Catholicism versus Protestantism, but we're dealing with entirely different religions and ways of life. Hinduism and Islam and Judaism and Christianity all swirling together. Like, how plausible is it that we could really go back to states establishing different religions? Would that just create a kind of chaotic religious scene in America? I'm just kind of wondering what the real life application of this would be given the changes.
Yeah. I mean, part of our argument, of course, is just like all the ridiculous things. You might have to take it all the way up to the Supreme Court to kneel in a football field and pray. That's because of this case, right? So that's part of our point. It's like, this is absurd. It is responsible as at least the predicate for hollowing out America of its historic public religion. And the most, inconsequential things that used to be, anyone arguing for disestablishment in the 19th century was not bothered that there were Bible readings in public or prayer and, all these sort of normal things. That was not establishment to them, So part of our argument is like, this is the reason the courts are able to take this so far. You have to roll this back if you don't like the way this is going. But obviously our things we'd like to see happen are deeper than that, or go further than that, to your point, that this is also, in its own way, a continuation of the Dobbs decision, and that it's trying to recover a more federalist landscape and polity. And one of the arguments we make is that it's actually the further diversification of ways of life that necessitate this. So if you're someone who doesn't like talk of national divorce or balkanization, regionalization, that's already sort of happening in many ways, and you want the union to stay together, this is the sort of time-tested and original solution. And from the perspective of an 18th century guy, they probably felt somewhat the way we feel, based on the limitation of their own experience. I mean, you can find plenty of comments like this. It's just like we're just too different. My favorite anecdote on this is there's a letter from John Jay to John Adams. And he's like, is it true? I've heard this, it's like a rumor. Is it true that I believe it's someone from Massachusetts, someone from Philadelphia, they got married? And he calls it he calls it intermarriage. This is intermarriage. And he thinks this is great. He's like, this is going to be so good. If we could just get more people to do this, marry outside their groups. It's almost like it's their races. Then we'll really have a new ethnogenesis of Americans. There will be more unity, so on and so forth, right? So they think it's very different. Like you're from a different country in a way, if you're from a different state, and in so many ways. So in that sense, it's not new, but objectively, our situation is worse, more complicated, and is new, right? At the same time, all we're saying is, we have one solution that's sort of built in, that the past 75 to 100 years has basically been dedicated to destroying. We should try to roll some of this back and let the solution work, if that's possible. So it's for the sake of stability and peace that you would allow for a diversity of ways of life, including religious lives, across the board. And you would just accept, California, Minnesota are very different than Florida and Texas, or whatever you want to say. That way, and you would have to accept that someone asked me this on another podcast. It's like, what if Minnesota, then they have like a Muslim establishment? Now I think there are all sorts of arguments from your history, text, and tradition for Minnesotans that they should make in that case, right? As Americans also, as historic Minnesotans, and do that. But in theory, you would have to allow that, right? There's nothing the other states, we've done it before. We go to war over things sometimes. But in theory, you would just say, that's how they live up there. That's what they do. It's not what we're going to do in Florida, but it's how they are. We can still have trade, all these things. But it's like a foreign country in this way. We're just in a sort of treaty with them that we're not going to bother them about it. So that's what you're signing up for. But what you're signing up for is also the possibility that you're in your own locale, you can have your way of life that's unmolested. So this is a potential solution. It's something approximating the original model. That was the only way, especially as the scale increased, as the population increased. I think the demand for this kind of model only increased, and we almost started right away, like tweaking it and sort of destroying it. So that's the goal for various fronts. It's like this stark separationism that was mandated, by our magisterium in the federal court is out of step with our historic tradition and the way we handle these things, both in form and in substance. This is just not an American thing. We've seen the deleterious results of handling it this way, because the ratchet only moves one way, right? It's just increasing secularization and public atheism. It's always against Christian things. It doesn't go the other way. So if you're a Christian, you have to understand, as the default, you are the one that's always the historic default as Christianity. You're going to be the one that is the sort of victim of any of these policies. There's only one way to progress, which is away from what you've had, which is Christianity. So you need to remove this very key, sort of linchpin, this tool that's everything flows from Everson. There's cases that are much worse in their rulings than Everson, obviously. Some have argued, like the public school prayer ones have a greater cultural effect than the prior ones do. I totally agree with that, but it doesn't negate that Everson is the source code, right? As just later iterations of the same doctrine as it grows through the 60s. It wasn't until the 60s that you finally remove tests for office. You remove, all sorts of demonstration of sort of public Christianity and religiosity. So if you think, as Christians should, that not just religion generally, but true religion is essential for the republic, you have to find a way to allow it to come back into public life. And if you would like to have at least your enclave, your own state, that is a Christian one. You have to remove the impediments to that, and also allow for, California or whatever to be very different, and that's fine. This is the settlement we signed up for in the 18th century. So.
And I'll just be quick because I know we're going to be wrapping up here. But one quick question is, I've seen in some conservative legal scholars, I think Josh Craddock at First Things, Robbie George, they've been talking about, well, the 14th Amendment, persons in the 14th Amendment, that protects babies who haven't been born yet. And therefore, it's kind of like a federal case, say, in abortion, that it wouldn't actually be up to the states. States would not have that right. It would be out of their purview, that the Constitution sets that. And it seems like in other cases, you see this too, where, constitutional amendments, say for marriage. I think even Ronald Reagan in the 80s, I think he might have backed that at one point. What would you say to those kinds of types of efforts? I think I know based on what you just said, but what would be your take on those?
Yeah, as a matter of the 14th Amendment interpretation, I totally agree with Craddock and those guys on what it means. I think you could have done that post 14th Amendment. I also think that it's a weird question for to try to run back into the 18th century, but I could totally see the federal government, meaning basically with the consent of all the other states, being like, look, we're in this agreement with each other, and we hear you're doing like child sacrifice to the tune of like tens of millions, and we're just not going to have that. This is not part of the bargain. So that you could have some lines in this way, but our point is just, it's very clear in the maintenance and reaffirmation of the state police powers that most of the states would have said they inherited through their royal charters. They're not derivative of anyone else. It's the default, right? That's why you have the 10th Amendment. It's not people will cite the 10th Amendment on this. That's fine. It's like recognizing something that already exists, right? And it's also telling you what the nature of the constitutional settlement is. So it's the states giving things up, not the other way around. This is why I always say governors are not lesser magistrates. Their authority is not derivative of the federal government. If anything, the president could be argued to be that he's a lesser magistrate. It doesn't make a lot of sense because our system's weird in that way, but it's if you're following the logic, it does. Point being, the moral and religious questions are just squarely and historically rooted in the police powers. That's what it is. Policy, right? This sort of language. And these are domestic affairs, and you would not have had a constitution if you had demanded uniformity on these things. That's like the only thing that's clear, in my opinion, from the ratification debates. They don't spend a lot of time talking about the First Amendment. What is clear is they're not going to accept uniformity. And the 20th century represents an attempt to make, as Ben mentioned earlier, it's the polar opposite of what the Establishment Clause is doing, is to enact uniformity of a different kind of religion. That's what the 20th century is. So this is just a obvious violation of the original constitutional order, and they just would have been entirely comfortable with other states setting their own moral policy and being very different. They may have had something to say about it, but this is just the game. This is what you're allowed to do. So that's why toleration varies. That's why the establishment bundle of sticks varies. Everything's very different about their ways of life from their perspective. They think they're almost too diverse to make it work even. So we're just saying, given everything that's happened since then notwithstanding, which most of the diversification that we're talking about that is a problem for all this has been because of federal policy unto uniformity over the past 175 to 100 years. So, this is one attempt to move the needle and say, let's return to, in this way, diversity is the strength. You can allow for this kind of communal and state level diversity. This is what it means to have federalism, and maybe that will set us up on surer, formal and kind of structural footing to deal with the untold amount of diversity that's been sort of rammed down everyone's throat at scale. Maybe you could figure out a way to settle things this way.
Very good. Yeah, it seems to me, last comment I'll make is that if we got the right Supreme Court case, and you guys talk about some of the potential cases, there was this Oklahoma charter school case or something that kind of defaulted 4-4 when Barrett recused herself. But there are other cases in the pipe. But if we get the right case and we do get an overturning of Everson, it really is it's a regime change in a sense. It's a return. It's a complete reversal of this kind of homogenization and uniformity around a consolidated, national ethic or lack thereof, really, that a secular ethic that is imposed on the states. And, it would be in a way, a return or a envisionment of the founders' ideas, and totally foreign to most Americans, though, and very scary. But it really would be a constitutional shift, like you were saying. The states are actually more foundational.
Yeah.
The governors are not lesser magistrates, almost in a sense they're prior or senior magistrates to anything that comes in the federal government, since the state governments originally, by the original design, had to exist before you could even have the Senate or a president or anything like that. So yeah, any final comments, Timon, on the article, or just the legal landscape before we wrap up?
Yeah, we're certainly calling for again, none of us are like activist sort of lawyers. None of us authors wrote for or worked for ADF or something. It's their job to be creative and find ways to do that's appropriate while still representing their clients. But the Drummond case was one was happening as this article was going to print, and we had to change it at the last minute because it hadn't been decided when we initially submitted the final draft, and then it was, but it also wasn't. So our point on Drummond is like basically run it back. Someone needs to do it again. Because you had this strange recusal from Justice Barrett, and then the gridlock 4-4, which means you get no indication of who voted what way or why, right? We have no idea. It's a total black box. So you just maintain the state opinion. And I was on another podcast about this and was like, well, isn't that bad because Oklahoma's super red and they decided against, this Catholic charter, online Catholic charter school. And it's like, well, yeah, in one sense, but also the state courts have to follow their precedent. And they've been told through Everson that this applies to them. And then it's been, the precedent is very clear. You're not allowed to have this thing. So they're just sort of following orders, right? You have to have the Supreme Court weigh in on this to break it wide open so that then you could have state courts in red states actually decide something and see what they want to do. And maybe you'd have states that totally decide at their legislative level, no, we're just going to maintain the status quo. We like it. We like the Indian, Hindu goddess statues in Houston. We like that kind of thing. We're going to keep it. And then people could decide where they want to go, right? Maybe, the state over is a little more receptive to maintaining a sort of Christian public life. It would allow you to more aggressively, I think, and meaningfully enforce and or enact more local legislation as well. I mean, all your like obscenity laws and these things are usually municipal. They're just not enforced anything because it's partly the culture and partly like where's it going to go after that because someone's going to appeal it, these things. But those are all around. They just need to be executed. Prosecutorial discretion needs to be reversed in that way. But you have to get this sort of monkey off your back first, right? Which is, if you go to the Supreme Court with any of this stuff in the past and they can't identify the secular purpose or it looks unfair, all these things, all these various standards that have been, debated over time. It was just a non-starter. Like it's not going to end up well. But the court has, last thing I'll say is like at various points, Justice Thomas has been wanting to reassess Establishment Clause jurisprudence for decades. He's always, anytime he can make a point in this way, he does. And his main argument, I think, is that, which we talk about in the piece, so people can go see what his fuller argument is. But it's just like, this is what he would call a federalism amendment. So I think he would see that the free exercise clause can be incorporated, but it's impossible to incorporate the Establishment Clause. And other justices too have just expressed frustration with Establishment Clause jurisprudence. Needs to be something better. It doesn't seem workable or correct, especially because you've had various cases having to do with generally available public benefits that will be denied Christian groups. So clearly this is not workable. Basically, back to the Everson case. So anyway, I think there's some appetite there in the current Roberts Court. And so people should go for it right now and start. You got to do what the left did for, they're quite happy. They were quite happy for decades to keep bringing the same types of cases and just trying to get a chink in the armor and throwing things at the wall to see what sticks. And they did that for a long time and sort of tirelessly. So you just have to start doing that and get the arguments out there. You have to remember every time you have, a ruling, a holding from the court, there's probably going to be dissents and there's going to be commentary. And part of getting good cases out there is, even if you lose, having good commentary get out into the public mind. I think that's a big part of it. This is how it happened in the direction we're trying to reverse. You just had these things are actually way more powerful even. And you see this with the gay rights cases. That becomes the most powerful, not in anything that's actually being policed, but in social stigma and expectations. So this is part of the game also.
Very good. Well, that's enough for now. Thank you, Timon, for the article and for sharing. Thanks, Mike, for chiming in. We will drop Timon, Josh's and Yoram's article in the show notes so that you can read it at your own leisure. Thank you for listening to the American Reformer podcast, and we will see you next week.
You can find American Reformer on the internet at www.americanreformer.org or on x.com, formerly Twitter, at @AMReformer. Don't forget to like, rate, review, and subscribe to this podcast. Please consider supporting us today by making a tax-deductible donation through our secure online donation portal at americanreformer.org. That's americanreformer.org.